Hello friends, welcome to my channel Sonal from USA, and today I'm really excited that I have something, I was looking forward to this kind of a podcast to have an immigration attorney with us to share more information inside that, so many changes are happening in the immigration landscape. So I have Mr. Kirti Kalara from Chugh LLP. So Kirti, thank you for joining us. And before I introduce Kirti, I just wanted to give a little brief about Chugh LLP firm. Mr. Navneet Chugh is basically a founder and managing partner of Chugh LLP. He is based in California, and they have offices in US at multiple locations, right? 5 locations and half a dozen affiliates in different countries, right? India, Pakistan, South America, and many other locations. They are into 15 legal practice areas, and Mr. Chugh has an extensive experience in wide variety of corporate, tax, immigration, litigation, merger and acquisitions, and he's attorney and as well as CPA. Mr. Kirti Kalara is a partner in Chugh LLP, and he's also based in California. So they don't face the winters like Boston. But
Yes, definitely not as cold out here.
okay. So Kirti is also attorney. He is specializing in immigration. He's based in their California office, and he's also done his JD from Thomas Jefferson School of Law in California, and he's been practicing immigration from long time. So I'm glad to have you here, Kirti, in the podcast, because I was really looking forward to have someone, who will legally advise on the changes. There are a lot of things that we are seeing as President Biden has come, signing a lot of executive orders. We are seeing some positive changes. So we have some questions from the, students community and the people who are going through the H1 processes, with the changes which are happening in the landscape. A lot of questions and a lot of anxiety in the minds of the immigrants that we have. So with these question answers, we will try to clarify those doubts, and if we get more questions, we can always compile and get back to you on those questions. Before I start, do you want to say something about you, your firm, to all the viewers that watching this podcast?
Yes. So I've been practicing immigration for about 13 years, and our firm has been in this business for about 25 to 30 years. I'd have to go back and check with Navneet the exact timing on 25 to 30 years,
Okay.
but he's been doing this for quite some time.
Wow.
And we've helped our clients throughout this different administration, different phases of immigration for any types of ups and downs that they've had in this business.
Mm-hmm.
And I myself have personally been doing this for about 13 years. About 8 years ago or so, I became partner at this firm.
Wow.
And been leading a small group myself within the firm. And it's been fun, to say the least, especially with the latest administration changes and the new changes that have been coming up recently. So we're looking forward to answering your questions and helping our clients and along the way.
Absolutely. Thank you so much. I really appreciate that you joined my channel. It's a small purpose of helping people and teams, immigrants, in a different way.
Absolutely.
So this is the way they can understand, and if they really have any questions or need legal help, they can always reach out to you.
And I would just like to preface that with, I won't be answering any case-specific questions because, as we discussed, we're going to be discussing these topics in a general manner as they apply to individual cases differently. And also just remind everybody that the topics that we're going to discuss are about things that are still pending with Congress. So a lot of things may or may not eventually get through to the final regulations, and a lot of things may or may not happen as this thing progresses in the next year or so.
Absolutely. I totally agree. And it's absolutely not an individual specific advice that we are talking about. It's very generic. Let's get started. I've been getting these questions, especially from the students community, because they come here with the hopes that they will complete their masters and then they will, get their OPT and then they will get their H1. So, with the recent changes, where USCIS has been experiencing some delays in the lockboxes in issuing receipt notices to Form I-765 for OPT, optional practical training for F1 students. So, what are the actions USCIS took to remediate these delays? Can you please throw some light, so that students feel little better about that?
Yeah, this is a pretty hot topic. Everybody is concerned about delays on their petition, not just for students, but for every single petition that's filed with USCIS at this point, right?
Mm-hmm.
So specific to the issues with the lockbox and students, let's talk a little bit about what their normal interaction with USCIS. They normally file a I-765
Mm-hmm.
with USCIS to get their employment authorization to get their training on OPT. Now, the 765 is a petition that's normally linked to other types of petitions as well, such as an AOS and other forms of employment authorization that are plentiful, right? So.
Mm-hmm.
If you look at it, the delays, let's take a step back first. Let's see why the delays happened. First, the pandemic, obviously, right?
Mm-hmm.
Things shut down, and USCIS is not very digital, and it definitely was not before the pandemic happened. It's getting better every day, but they're definitely not digital, so there had to be a person physically there, logging things in, giving the files to the adjudicators, and a lot of that came to a halt. And the amount of mail and amount of applications and petitions USCIS can receive in any given day is substantial. And you can imagine being shut down. They never really did shut down, but they slowed down. They separated out their employees. Only a few people came in at a time.
Mm-hmm.
So you can imagine the backup that might have created.
Absolutely.
And the delays that it created.
Mm-hmm.
And then, while they were getting adjusted to the pandemic, trying to speed things up, came the October visa filing frenzy. So as you may know, that there were a lot of employment-based visas that became readily available, and people were able to file their green cards. And with those green cards, 765 is one of the applications that gets attached to a 485 adjustment of status filing. So, these two things coupled together cause a significant delay, and things that normally would take 3 to 6 months were taking like 6 to 9 months, 6 months at a minimum, as opposed to 6 months at a maximum, right? So, and other petitions were affected to a point where they weren't getting adjudicated for years at a time. There's been a lot of events that contributed to this, but USCIS and took note of that, and a lot of agencies informed them of how their delays are negatively affecting their businesses and how they're affecting students. So they issued certain types of flexibilities to these type of petitions, right? Mm-hmm. So one of the things that USCIS did to respond to this issue is they adjusted how they issue the EAD. For example, generally for a post-completion OPT, you get 14 months to complete your 12 months of employment on EAD, but the student has to wait a few months to get their EAD cards, right? And it's usually a few months, so they miss out on, and it comes in within like their third month or so of their application if they file it, significantly close to the end of their time. So they normally miss about a month or two of employment for their post-completion OPT. But now that these things weren't being adjudicated for 6 months at a time, they would miss quite a bit, right? They'd be down to only 6 months or 7 months of optional practical training. So USCIS
Mm-hmm.
changed that, and they made it so that, it would not start, the 14-month period would not start until the EAD is approved. So they can continue use that full period of 12 months to get their optional practical training in. And in addition, if you were issued a short EAD card, you can get that corrected.
Mm-hmm.
So they allowed that flexibility to help the students in the meantime.
Okay. So in the sense, basically, if there is a delay, they are not going to count that delay, and the clock would start only once the person receives the EAD, OPT EAD.
Right. And again, they still may have some issues on how they issue the EAD card, and if they need to be corrected, they can be corrected.
Okay. I think that's kind of a little bit of a relief to the students who are like, waiting for their EAD is not received or not seeing their receipt notices, due to the delays.
Right. And the best person, it won't even be an immigration attorney to find out about OPT and EAD issues.
Mm-hmm.
I consistently remind our clients who are looking to, advise the students that they have on OPT on how to continue their training and whatnot, to go back and check with your designated student officer. The DSO have all the ins and outs of these issues from before even anybody else gets them.
Mm-hmm.
So the DSOs are like the greatest resource. It's even better than going out and trying to find an attorney to advise you on how to deal with OPT and EAD issues.
Okay, so that's a very good input actually. So students who are concerned, they can actually go to DSO and find out the status of what is their case and where it is.
Right, absolutely. They're the best resource,
Okay.
and I've been advising that way from the very beginning.
Okay. That's perfect. That's really good news for the students that, delay is not counted and they can actually check their status on DSO.
Right.
Because students definitely cannot afford to hire immigration attorneys.
Yeah, and you'd be paying an extra cost that you shouldn't really have to,
Absolutely.
especially as a student.
Correct. With new changes coming into picture, our student community is also concerned about the H1-B changes which are happening and how they would impact them in the long run. So like earlier it was a lottery system, where everything was like a luck, lucky to lucky kind of a situation. And now that it is going to the wage-based system, especially students and the people who are coming at, beginner or with 2-3 years experience are really concerned how this is going to impact them. So can you give some insight what is happening on this H1B scene and how it would impact the future of the students and the people who are coming on H1 here, with a lesser experience?
Well, let me start with this. This year's cap is not different. It's the same as last year. It's the registration system that we had last year, and we're using the same system. There's no wage-based selection or priority that you get out of it. That was that was put in. It was introduced by the Trump administration, but it was put on hold by the Biden administration, and it's on hold at least until 2021. The wage-based changes will not come in until then, if there are any, and I think they will be played around with quite a bit because of all of the pieces of immigration legislation will be traded off to satisfy all the people that are needed to necessarily vote on the changes, the immigration overhaul. So with that said, that there is no hard, fast idea as to how the wage base is going to impact students in the future or whatnot. But just to give you a little background, what the wage-based system overhaul would require, it would make it so that the employers can only file an H1-B if the wage to the foreign worker is greater than the annual wage paid to the U.S. citizen or permanent resident who have the identical work in the last 2-year period. And they would make the minimum salary $110,000. And you can imagine how absurd that number would be for a fresh grad to make that much money right out of college, right? So you can imagine the impact that it would have on the F1 and OPT program. And they had other provisions about suspending the F1 and OPT program in that as well. So the wage-based system, as it molds out, will change and we'll get a better idea as what it is. It's not going to completely go away, in my opinion.
Okay.
There will be some adjustments made to it, but it won't be nearly as extreme as the one that were introduced by the Trump administration. And these are going to be essentially bargaining chips for the overhauling of the immigration system that we have.
So they still have a hope that they can get employed and they can get their H1 through this system, if at all the wage-based system gets implemented.
Yes, absolutely, and it's not a end-all type of situation. Even if there is some sort of wage-based system that's implemented, even with the one that was introduced by the Trump administration, there was a lot of challenges that were going to be had in the court system, so they were going to have to adjust it anyways. But this, now that it goes through a congressional process, it'll be a much easier adjustment to the process. There won't be a period of, there's a lot of pain that happens in the system, and then the court systems get involved and make changes, and then people in the meantime, are the ones that are impacted. This way, now with the congressional process, it'll be a more smooth, more developed body of legislation that comes out all at once.
And there were a lot of questions around this, like how would they decide the wage, because every city has a different cost of living, right? Like, for example, California is being most expensive, followed by then Boston and some other states, versus there are B or C class cities, which are like less expensive. So how that entire structure would evolve? Do you have any insight or any slightest idea that we can, give it to people?
Well, so currently, when it comes to H1-B wages, they're determined by a labor condition application, which currently contains different wages for different wage levels, experience levels, education levels, along with different wages for different cities for people doing the same jobs in different areas, right? So that system is already there. Now, how will that play into the lottery selection process? It's to be seen how that could be impacted. So my guess would be that if there is any sort of input from the wage-based aspect to the selection process, it'll be based on the level as opposed to the salary amount, and I think the final system will do away with like a minimum salary. Maybe just be like, level 2s get preference or level 3s get preference. And again, I'm just guessing all of this stuff right now because we don't really know what Congress is going to do with the wage-based aspect of it, or if they're going to have it in there at all. But that's to be seen.
Okay. Yeah, but thank you. This is something that people are kind of anxious what will happen about the wage based, and especially people who are coming at a junior level, and the freshers are really kind of worried about their future, and that also going to impact the future of students who are coming in here for masters, right? Because they come here to get employed after their masters. So this is little weird question. I don't know if you can answer this, but many students who are here already, looking for their OPT, who have got EAD, not able to find the job, current lottery system, they may get through or they may not get through. If they do not find the employer, what are the options that you can suggest, if they want to continue to stay here in United States?
I think that's always the question that gets asked. It definitely is. It's strange in a sense that you want to stay within the requirements and the visa's eligibility, but at the same time you kind of want to make it work for yourself. So it's kind of hard to advise normally on what to do if, say, you don't get selected in the lottery and whatnot. I think the best thing to do is decide how your career path is going to be. So you feel that, hey, my education is currently sufficient and I want to now get some experience under my belt. Fine, you can get experience in different countries and reapply at a later year. Even if you leave the country, there are many other countries that you can gain your experience and come back. So just because you have to leave after your education is done, doesn't mean that you're now never going to be able to come back on an employment-based visas, right? There's people that study abroad that have never been to the United States come in on an employment-based visa. So
Absolutely.
the option is always to see what you want to do. Now, if you feel like, your education, I say you're on the fence, you don't know if you want further education, or if you want to get more experience, you say, hey, I like my education. I would like experience under my belt, but I've always also wanted to go get my master's degree or go get my Ph.D. or whatever that may be. If you want to continue, apply for a higher level of education. That's another way to, further your career, and with the a side effect that you get to continue to stay in the United States.
Correct. That's a very good advice, and people can look forward to having another master's or maybe enroll for a PhD or something like that.
Well, a lot of students come into the United States to just get their bachelor's, right? Now, if you go from a bachelor's to a master's, you're also increasing your chances to get selected in the lottery as well. So it may serve a dual purpose of not only furthering your career, but also getting you a better shot at the lottery.
Absolutely. So that's a very good guidance, and I'm seeing people are struggling, during the pandemic to get good offers, and especially people who will sponsor, the employers who will sponsor their H1-B in the future. What
Right.
is your opinion about, people who are looking at Canada as an option if they do not get a chance or stand a chance here to get an employer who will sponsor their H1-B? What are your thoughts on that?
I have seen people take that route. When I say I've seen people take that, I've only seen that from family members. But those are normally people that are frustrated with the wait period when it comes to getting your green card. Some friends and family of mine have decided, you know what, opportunity is there. I'm going to take it. I'm going to further my career, and they take that route. It's really entirely up to your preference on where do you see yourself long term. I think if you say, look, it doesn't matter to me where I live. I just want to further my career and grow and continue. You could potentially choose, a different country as your option. But if you feel like that U.S. is where you want to be in the long term, and this is where you will further your career the most, then I would say try to get into the system as quickly as possible. And what I mean by system to get into quickly as possible is get in on an employment-based visa, get your employment immigrant visa filed so that you have a priority date, and get in line. And if the backlog is significant, I know that people have been waiting years to get their priority date to become current, but the sooner you're in the system, the better chances you have of getting a green card, because there will be a change in the system, and it will be prioritized to the people that are already waiting in line, as opposed to somebody that's trying to apply when things get better. So I would, and if things get better, for example, they overhaul the system or whatnot, then there's going to be another frenzy. Then you're going to be in a natural line as opposed to the one artificially created by the caps of the amount of visas that are allotted. So I say get in there, get your place in line. I-140 priority date is yours to keep. Employer doesn't withdraw the I-140 for 6 months, and just have a place in line. I think that's what I would recommend.
Okay. That's a very good advice, actually. I mean, nobody thinks it's that much long term, right? That at least I want to be in the queue. People just, especially, people who are coming here, the students, they get really frustrated very fast. And not many people are open to look at different countries. Like you said, they can look at different countries and work there and then go back to their home country and then again refile and come back with experience, to file their H1-B. So that's a very good thought. So thank you for that. And just because you talked about these waiting time about the green card period, I know that in between there was an influential immigration advocacy group which was representing Indian Americans urged Biden administration saying, "Hey, do not issue any more H1-B work visas because there is so much long queue already waiting for green cards, for the years and years." So, any substance in that news, it's going to fly any further. What are your thoughts about that?
Yeah, that there's always a radical approach to these things, and I think of this as more of a figure of how do I say this? More of an expression of their frustration than anything else.
Mm-hmm.
And I completely understand their frustration. The catalyst that this advocacy group is proposing is still problematic, right? There must be a better way to show that the per country cap on green card is not sustainable through lobbying and continuing to show representatives at all levels of government that this GC issue has detrimental effects.
Mm-hmm.
And we need to humanize these issues. I think that'll be the better approach than to take it as a strictly business thing. Hey, and a mathematical formula. Hey, don't issue new visas because they're not going to get through the queue. I think that takes away from the American spirit itself, right? So we need to humanize these issues, and with empathies and stories to people that can put a grasp on, putting visa bans on nationals only continues to other this groups, right? So I think we still have to stick with the facts, right? The fact of the matter is that the Indian nationals make up the largest percentage of H1-B visa recipients, right?
Mm-hmm.
So obviously there's going to be a bigger queue if there's per country limitations on the caps on the immigrant visas that are issued, right? So obviously there's going to be a greater demand because there are more non-immigrants on employment-based visas here, and they've got careers that they want to pursue here, right? So it's counterintuitive to deprive those Indian nationals for the H1B visa because for many that's the only way that they can get an employment-based visa in the United States. H, L, O, and they're limited to that. There's no treaty-based visas that they can use that other countries have with the United States to come inside. So if you eliminate even H1B, then you're limited to outstanding visa and you're limited to L visa, which will be, not everybody's eligible for those, right? So I think there has to be a better approach to this, and I think the advocacy group is just trying to make a point when they do this, when they come up with these far-reaching, substantial solutions. But I think I don't see any weight to that. I think it's just pointing out the disproportionate issues that we're facing with the visa backlogs.
Okay, it is just an extreme way of proposing it in a different style. So you talked
Yes,
about the
absolutely.
H visa, L visa, and O. So I know most of the people know about the H1B. Can you a little bit elaborate about L1? I know it's a transfer visa, and the O, outstanding visa. And if there is any chance, if they have to plan, coming to this L1 or, L visa or O visa, or what are the kind of options they have?
Well, let me start with the second most common one, which is the L visa, right?
Mm-hmm.
So there's two types of L visas essentially. One is the L1A and the L1B,
Mm-hmm.
and there's different ways of how to apply for them, such as you can apply directly with USCIS, or you can, if your company uses a lot of these visas, they may have a L blanket in place where they can apply directly at the consulate.
Mm-hmm.
So the two main categories are L1A, which is reserved for executives or managers in the country. I mean, in the company that are currently performing executive or managerial duties in their either parent or subsidiary or a related entity in the foreign country such as India.
Mm-hmm.
and they're going to come and do the same thing or similar thing where they will continue to remain executives or managers when they come to the U.S. subsidiary, parent, or affiliate of that large multinational in the United States. There's no lottery system for this. Mm-hmm. There's no limitations on how many can be issued in a year. Mm-hmm. You can apply for these at any time.
Okay.
The second one is L1-B, which is for specialized knowledge. Individuals that aren't necessarily executives or managers, but they have specialized knowledge of the company's system, process, or product. And their knowledge is something that you can't just pick up somebody from a different location and somebody that doesn't know the ins and outs of the company and have them do those jobs. Mm-hmm. For example, something that would fall, and people think that, working with the company, knowing the ins and outs, that's not necessarily what will qualify you. It has to be something proprietary to the company. Mm-hmm. Sometimes some people that use these are the ones that were, important in getting the patents developed in that company. They were instrumental in facilitating or creating a new process that's unique to the company. Mm-hmm. And those and the documentation of that is pretty heavy and extensive. So those are two different L options that are available. And then the O visa is a little bit of a broader category. There's a O1A and a O1B, and it's restricted to, an O1A is restricted to individuals with extraordinary abilities in science, education, business, or athletics. And that doesn't include, the motion arts or television or motion pictures industry. And then O1B is specifically for people with extraordinary achievement in motion picture, mm-hmm. Television industry.
Okay. So people, if they have this kind of a skill set, probably they can look at but people who are...
Yeah, and they would know it, and it's not that... it is very unlikely that you'll have a student that will qualify for this. Say, for example, a student goes through the lottery system, does not get the H. Mm-hmm. They want to consider an O. I'm not saying there aren't people with these skills already off the bat. They're special, they're well known. There's a lot of students that have gotten accolades before they start their career that are tremendous and may qualify. But most likely, this will be people that are already well known in the industry, and they're people that have had years of experience, and they're unique in a sense, and they could potentially apply for this O visa.
Okay. So I know that President Biden was elected, and the moment he came into the presidential powers, people were happy because he signed some executive orders, immediately, bringing some good news on the immigration front. First being he removed the presidential proclamation on the Trump's pause on green cards, and second was he released the U.S. Citizenship Act of 2021 to the U.S. Congress, a bill that would overhaul the U.S. immigration system and bring an end to some of our former President Trump's most controversial policies. So can you share more information on this, as it sounds like a good news for the people who have been waiting for green card, then undocumented immigrants, then family-based green cards. There were a lot of restrictions on that, and expanding opportunities for the immigrants who are highly skilled foreign workers, with the STEM degrees. So can you elaborate more on these things?
Let me preface my response by saying that this bill is in its infancy and it has yet to be passed or even come close to that.
Okay.
I think their agendas are mainly focused on COVID-19 right now. So mm-hmm. you can imagine this is there, obviously, mm-hmm. it's what he ran on, so it's important. Mm-hmm. But I don't think it's going to pick up steam as of now. It may happen later on in the year when things go back to normal a little bit. And second, I want to say that this bill would likely be split up into little pieces mm-hmm. before it can be passed. It won't be one big overhaul. Congress generally refrains from them. They have a hard time dealing with them. So they may, if they find something that they all agree with, let's just solve that problem right now. But it it's gonna it's to be seen as to how it's gonna actually make its way through, right? But then let's also be clear that this is the first time in a while that an immigration overhaul of this magnitude has been introduced, in my opinion. And there may have been some in the past that I'm completely overlooking, and I apologize for that right now. But from the time that I've been paying attention to this in my practice, I haven't seen one where this type of level of introduction has happened. So, well, there's a couple of good things in there that I really would like to see go through and remain in the final bill. One is the F1s will now have a dual intent. Now, it's proposed in there that F1s can have a dual intent, making it easier for students to start immigration to wait until they get dual intent visas, such as an H, before they can go ahead and pursue their green cards. And then, go from non-immigrant to an immigrant at that point. Right now, F1 students have to show that they have the intent to return home once their education and studies are done. But if with this new bill, if it passes, it'll also make an F1 a dual intent visa. Then you don't have to deal with those issues about what the intent is of the student when they're applying for their F1 visa. A lot of times it gets denied because the officers don't feel that the student has enough. Sometimes these visas get denied by the officer because there's not enough connections or reasons for the students to go back. The second thing, which is still a pretty novel thing in my opinion, which is that the bill will create a pathway for F1 students that are graduating with a Ph.D. in a STEM field and could immediately apply for a green card. This is going back to what you had asked earlier about, what are the students' options. So if the student can get a Ph.D. in a STEM, which is really hard to get a hold of in the United States, there's a shortage. And if you can get a Ph.D. in a STEM degree, they would be exempt from the per country limitations for getting a green card. They'd be essentially a fast track. I don't know how that would look. I would like to see something to that extent so that the very high level of educated people remain in the U.S. and contribute back to the United States, right? And then the other thing that I liked about it was that there was some numerical increase on the amount of visas as well. I believe it goes to 170K visas to be allotted every year. And then there was also parts of the bill that would allow dependents to get employment while they're on a non-immigrant dependent visa. Like, for example, for the longest time, people on H4, because of the backlog, have been here waiting to get for a chance to be employed. There was something introduced where the H4 dependent can get employment authorization if their H1-B H1-B worker spouse was working on H1-B, but they had their green card in place process, so now they can apply for H4 EAD and get going. This is something different from what's been available to L visa already. They're trying to make it similar to that, where just like an L2 spouse, you can get your EAD for an H1B spouse on H4 right away. That's part of the bill. They're considering it. And it could be some good changes. I would like to see what comes about it. There's a lot of good ideas in there, but I think they're going to need a bipartisan support to get this through, because even people on both sides can't agree on how this should be rolled out and what's important to United States and not just important to the immigrants as well.
Yeah, but that would be awesome, right? If somebody comes on H4 and get a job like L2 within 3-4 months, apply for EAD, that would be so awesome.
Yeah, and I understand how that has been a pain point for a very long time, especially because of the backlog. right? So it was not a temporary thing. Say somebody comes in on H1-B, their spouse joins them on H4, and then they get their green card in a few years, and the spouse can get their green card and work too. Now, some of these spouses have been eager to work for like 10, 12, 13 years while waiting for their spouse to get a green card. So, it just seems a little unjust. And it had good intentions, was to protect the employment market in the United States. But, with the historic unemployment lows that we had before the pandemic hit, it doesn't really hold that much water. So there may, we'll see.
Okay. So these are just kind of in the proposal stage, and we do not know it will still materialize or not.
Right. And not just that, we don't know how the employment market will hold up past the pandemic, right? Mm-hmm. So if there's periods of long, high unemployment rates in some areas, then these issues may get revisited from a negative standpoint.
Absolutely.
As opposed to if you go back to very low unemployment again, then these dependent visas to get for an H4 specifically, to get an EAD, chances may go up, may get better.
Mm-hmm. Yeah. And what happened to the family-based green card? I know that it was only available for the immediate family members, and then they had banned, the not immediate family members, like only parents were allowed, or the immediate spouses. Not even the parents were allowed to file the GC through the family-based. So all those restrictions have gone now?
You could always file the petition.
Mm-hmm.
There was never a ban on filing the petition. It's about applying for the visa abroad.
Okay.
So for the immigrant visa processing abroad, it's just that they were placed on hold, right? So you couldn't come in. If your green card was ready, your priority date was current, you should technically be able to go to the consulate and apply for your green card. But that was placed on hold. But the actual filing that people were able to do for their, parents, relatives, spouses, and siblings, the I-130 petition, you were still able to continue to file them throughout that process the entire time.
Okay. Sounds like there are some positive changes on the horizon, and which may come through. So
yeah, I mean it's exciting. We're all all immigration attorneys are pretty excited, nervous, confused at the same time, because it changes so often. And I know you and I postponed this a couple of times so we can get some more concrete information, but it seems like this is going to be the immigration environment for some time. Right. So hopefully we get some more concrete facts that come out of this, and we can advise people in much more than just a hopeful manner.
Absolutely. We are just hoping for positive thing. But before we conclude, I get this question very often now that due to pandemic, situations have become remote and people can work from anywhere. We used to get these questions very often from the H1-B workers, hey, can I work from this state because my spouse is there? Say so somebody is working in California, organization is based in California, but spouse is in East Coast, can I work from there, and if yes, how long? Second question that I used to get, hey, I want to go to India because my parents are not well, can I work from there, if yes, how long? Or maybe because I have a PR in Canada and I want to protect my PR, I want to make some visits and I want to work from there. So do you have any kind of a guidance for those H1B, immigrants who plan to work from different states, and how long they can work in such a remote environment?
With the pandemic, working remotely was a matter of lifestyle in the United States. You didn't have a choice in a lot of situations. So remote work had become more and more acceptable, and I'm speaking as if the pandemic has already ended, where we know it's not the case. There's people still working remotely, and the work environment, in my opinion, is going to change significantly as to be able to, require people to go in physically and whatnot. Even as for myself, I've worked throughout the entire pandemic from home. But I think for the sake of employer efficiency and whatnot, some employers may be okay with people working from home. Some employers may not. But regardless, I guess that's a separate wrinkle. The wrinkle that you're talking about is how will that affect their visa status, right?
Correct, because of the LCA-based system, right, where it's based on location.
Right, and I think now when it comes to how long you can work from home and whatnot, I think it's going to become, in my opinion, and I don't know how USCIS is going to go with this or the Department of Labor is going to deal with this, is that because of the LCA-based system, you're required to be at a particular place in case the DOL officer shows up for an audit and whatnot. And you have to make sure that you list the right LCA location so that you can be paid appropriately and whatnot. Working remotely creates a big conflict, right? So I think there is no reasonable amount of time I could say, like, hey, you can work remotely for a few months and it should be okay. People want to go to India and work for a few months, it should be okay. There's no reasonable amount of time I can say. I think the key to keep in mind is you're filing an employment-based visa to come here to work in the United States. And you're specifically requesting to be physically in the United States so you can work. Now, if you go back and say, I want to work remotely for a certain amount of time, for 3-4 months at a time, it brings in the question of whether you really need this visa to do this job in the first place, right? So if you can remotely work, then why do you need to be physically in the United States? So it creates these natural questions. They may not play out in the regulation itself, but it creates these natural questions, right? So now, with that said, I think that working remotely, as long as there's a reason, like a very compelling reason, like COVID-19 was a compelling reason why the person had to work remotely for some time. And when I mean remotely, I'm talking about from their home, not in an entirely different city or state altogether. And there has to be some proximity between work and home so that you can reasonably justify that you're working from home due to the current circumstances. But we live in a global environment. People are traveling. If you're traveling from work, for example, then there is no issue in terms of, hey, you got to go to India for a few days to work and stuff. You can work from India. Nobody's going to stop you from working for a few days a week out of India while you're still employed with a U.S. entity. But if you say, hey, I'm going to come to the U.S. and work for a few months, 3-4 months, and all of a sudden you said, as you said, my parents aren't well, I'm going to go work remotely for 6 months out of India, that may not necessarily fly. And they can't continue to pay you in the United States when there's no actual employee working here. So I think this remote work situation is going to be tricky. And I think when it comes to immigration and employment-based visas, it's going to revert back to the original way where, these visas require these individuals to be physically present. And the citizens and green card may work in a different manner going forward. But I think if you're going to be on a temporary employment-based visa, they're going to want to see some physical presence. And I'm just guessing. I don't know how this is going to actually play out.
Absolutely. I completely agree because I keep getting this question, and I've seen as an HR professional, people ask this, hey, it's anyways work remote, right? Can I work from, say, India or, say, Canada or whichever location? And that is where exactly precisely I also think that you've been employed in US for a specific reason. You've been brought here for a specific reason to work here. If you can carry out those responsibilities from anywhere, say India, then why would company file your H1-B to come here, and for you to work? So that defeats the whole purpose of having this kind of a visa.
Absolutely.
And getting people working here. But thank you very much. This is a controversial question, but thank you for answering it. And I think people who are watching got the gist of it. I mean, people can take it in their favor, but it definitely means that you are H1B employee, and you're here for a specific reason to work. And
Right, and I think the key thing to keep in mind is that there has to be a compelling reason, and for example, the main example that comes in everybody's mind is COVID-19.
Mm-hmm.
There was a compelling reason to work from home. If there's a natural disaster in the area you work, the office is not up and running, you can still continue to work from home. And if this is a prolonged period where there's going to be work from home and the office as a continuously, then you have to list that in the extension or the transfer, or even go back and amend your current petition to include the fact that there's times when the individual will be working from home and the office. You would list both of those locations on your LCA.
Okay.
You're going to say, for example, there's there's another situation where there's a pandemic or which requires that, hey, we can only have office filled at 60% capacity, so we're going to have to rotate as to who comes in.
Mm-hmm.
At those times, you're going to have to file an H1B, which indicates that he's going to work from his home office, and he's going to work from our office 60% of the time, then 40% of the time he's going to work from home, and you would list both of those addresses in the LCA itself.
Okay.
So say, for example, I'm in the Bay Area in California. So if I work in San Francisco and I live out in the suburbs in the East Bay, I would have to list my East Bay address and my San Francisco address and put in an itinerary as to how often do you feel that you'll be at those locations working.
Oh, okay. But that doesn't allow a person to work from a different state. So, for example, somebody's company is in San Francisco, and if he decides to work from North Carolina, will that be allowed, or he will have to amend a petition to do that? Or that is like totally not allowed because his H1B is for that location, and now he's totally going to a different city and state.
So you can have multiple locations on an H1B petition.
Mm-hmm.
Say, for example, if the individual is to service a company that has multiple offices, one in San Francisco and then one in North Carolina, somewhere in North Carolina. Let's pick a city.
Charlotte.
Charlotte. There you go. So if the person's going to work in San Francisco and Charlotte, you would file an H1B that lists both cities as the locations of your employment. Now, what will USCIS will want to make sure is that this is not speculative employment. So if you're listing multiple cities, USCIS can think, hey, this is speculative. We don't issue employment-based visas for speculative employment. Mm-hmm. So you would have to include an itinerary saying, hey, from January to April, this individual is going to work in San Francisco. From May to October, he's going to work in Charlotte. And then he's going to go back to San Francisco from, November onward. So you would have to create an itinerary. You would list both locations. It could be in separate states, but as long as you're clear and upfront about it, for example, the person has to do some development with the R&D team in San Francisco, and then he's going to have to go to implement it in Charlotte. You just include that in the H1B. You don't have to file an amendment every time.
Okay, valid point and very good information. I'm sure people who are watching found this useful, and a lot of questions that they have in their mind are getting answered, and I'm pretty sure that there would be many more questions which would come up. So I would request them to send their questions in the comments, and if we get a lot of questions, I can compile them and then we can have a podcast again to answer those questions. But I really appreciate Kirti for your time. I know you have a busy schedule and we went back and forth so many times, but really appreciate that you gave me this time, and thank you to Navneet as well, for allowing the entire firm to contribute to my channel. You have any word of advice to the students or the H1B petitioners who are working here?
Absolutely. I'm first of all, thanks for having me here. I appreciate your time as well. When it comes to giving general advice, I say just when it comes to employment-based visas and immigrant visas, I specifically work in employment-based, so my clientele normally asks me questions about what is the general approach somebody needs to take, and my answer is always something that they don't want to hear. They don't want to hear about the things that I say. They want to hear about how they can extend their stay in the United States, how they can pursue their career in the United States, because the United States, it still has a lot to offer, and a lot of people want to work here and live here.
Right.
But what I tell people is focus on the career aspect of your life. In education and career is where you need to focus, and if that means it leads you towards immigration in the United States, it's wonderful. But if it doesn't, who knows? It may lead you to better opportunities elsewhere. So don't focus on on building your life and career around your immigration to the United States. Focus on building your life and career itself, and if immigration is a part of it, it'll flow along, and it'll tell you this is the best place to be if that is essentially what it entails when you progress in your career.
Very good advice, because I get a lot of students asking this question at this point in time. Is it a good time to come here for masters because of the expenditure involved and the kind of visa situation and the changes which are coming in H1-B landscape? I think this is the answer for it. Thank you so much. This was very insightful. I mean, I also learned a lot of new things that as an HR professional, that I always thought what to answer for a person who comes with H1-B saying, hey, I want to work in India for 6 months, can I work? So thank you so much. Thanks to you.
Yeah.
Thanks to the entire Chugh firm for the support, and I look forward to have more podcast with you and your team.
Absolutely.
And we'll see in the future again. So till we meet next time, thank you so much.
Sounds
and
good.
bye-bye.
Thanks for having me. Appreciate it.